Welcome to today's Employment Standards presentation on administration and enforcement. My name is Barry Mullaney, and I'll be your facilitator for today. So, let's get started. The goals for today are to provide you with a mini overview of Alberta's current employment standards with a focus on administration and enforcement. And we'll also highlight some additional resources to assist you in finding more detailed information. Please be aware of our disclaimer and copyright notice. I'll give you a moment to read it. Basically, we've made every effort to give you the correct information, but if there are any discrepancies between this presentation and the Employment Standards Code, the code will prevail. And please note the copyright of this presentation belongs to the Government of Alberta. So, what are employment standards? The Employment Standards Code provides the minimum standards of employment. Employment standards rules apply to most employees working in Alberta with a few exceptions, like those who work in federally regulated industries such as banks, telecommunications, and air transportation. These industries often have alternate legislation defining those workers' entitlements and protections. When covered under Alberta's employment standards, employers and employees cannot make agreements for less than the minimum standards. There are some unique rules for different industries found in the regulation, like the way overtime hours are determined for the oil well servicing or trucking industry, or how general holidays are treated for construction employees. The Employment Standards Code also establishes the framework for program delivery and enforcement of the entitlements under the code, and this is our topic for today. And while the code establishes minimum standards, an employer can choose to offer greater benefits to the employee if they wish. Let's review what the Employment Standards Code covers. Hours of work in a day and minimum wage, overtime and overtime pay, rest periods required in a day or throughout a month, general holidays like Christmas and Family Day, vacations and vacation pay, unpaid job protective leaves like maternity leave or bereavement leave, termination and notices associated with severing an employment relationship, employment of youth, payment of earnings and the record keeping that must occur. And it also includes program administration and enforcement. And this will be our main focus for today's presentation. Our agenda for today is as follows. First, we will do an employment standards mini overview, and then we will look into employment standards administration and enforcement, including an overview of the complaint resolution process within employment standards, roles of employment standard officers and the employment standards director. We'll also examine voluntary resolution, the mediation process, and enforcement tools and action. A moment ago, we mentioned the areas the Employment Standards Code covers. Let's do a brief overview of those rules now. A reminder, if you would like to learn more information on any of the standards we're reviewing today, visit our website or check out our other webinars. Now, let's begin by reviewing an employer's requirement for record keeping. A job application, a letter of offer, or an email are probably the first types of records an employer will begin to keep when hiring a new employee. Proper record keeping is not only useful, it is mandated in the legislation. Listed here are the fundamental documents that all employers must keep for their employees. All records must be kept for a minimum of 3 years. Some categories do not apply to individuals employed as managers, supervisors, professional employees, or outside salespeople. For more information on the exceptions, visit our website or check out the regulations. The keeping of complete and comprehensive records will assist in resolving any disputes between an employer and an employee. If a complaint is brought forward, employers would be able to support their position by providing these records as evidence to an officer. If an employer does not keep records, an employment standards officer is permitted to make an assessment for outstanding earnings used in any manner the officer considers appropriate. It's important to note that the obligation for record keeping lies with the employer. If employers transfer this requirement to an employee, there is an inherent risk involved, and this practice is not in compliance with the rules. Employers may choose to keep paper copies or electronic copies. Regardless of the method, though, an employer must be able to provide records to an employment standards officer upon request. Texts, emails, or Facebook messages and the like are important for employers to document. Listed are some other records that are not mandated to be kept by the legislation. However, thorough documentation of all relevant interactions between parties is very helpful in resolving disputes. The list is not exhaustive, and there may be many other types of documentation that employers and employees may want to keep. The employer is also obligated to provide a statement of earnings to employees at the end of the pay period. Again, the statement should be in paper or electronic form and contain all the categories listed on the slide. Providing this information to employees helps them understand what they're being paid for and when. This allows for open communication should there be any discrepancies with pay or records. Now we'll do a broad review of some basic employment standards rules. We want to highlight these are the general rules, but ask you to visit our website for the full details of each category of entitlement, as there are exemptions and exceptions that exist. Let's start with wages. Wages are to be paid for work that has been performed. Hourly wages, salaries, or commissions are all examples of wages. In general, the hourly wage is $15 per hour. However, weekly and monthly minimum wages do exist for specific workers in certain roles and industries. Entitlements like overtime pay, vacation pay, general holiday pay, and termination pay are all calculated using wages. When it comes to overtime, most employees are entitled to overtime pay for any hours worked over 8 hours in a day or 44 hours in a week, whichever are greater. This is known as the 844 rule. The overtime pay must be a minimum of 1.5 times the regular wage rate. Banking time is permitted with a written banked overtime agreement, and overtime is banked at a rate of 1 hour banked for each overtime hour earned. If banked hours are not taken within 6 months, they are to be paid out at the 1.5 times the wage rate. Managers and certain professionals like engineers, accountants, and insurance agents are not entitled to overtime at 1.5 times the wage rate, but could still be eligible for straight time for all hours they work. There are rules that set out the maximum daily hours of work and rest periods for employees. In general, the code requires that hours of work do not exceed 12 hours in any one day. Employees must receive at least a 30-minute break for each shift that is more than 5 hours, or two 30-minute breaks for shifts that are 10 hours or more. Rest periods may be paid or unpaid. Employees are entitled to at least 1 day of rest per week. However, weeks can be combined, and employees may be required to work up to a maximum of 24 consecutive days before receiving 4 mandatory days off. Establishing rest periods and maximum working hours supports the goal of having safe, fair, and healthy workplaces. Additional rest periods are established through vacation and general holiday entitlements. With respect to vacation time, employers must provide an annual vacation to most employees based on the employee's length of service with the same employer, so that they can rest from work without loss of income. The minimum entitlement is 2 weeks a year for those with less than 5 years of service, and 3 weeks for employees who have 5 consecutive years of service or more. Eligible employees are entitled to time off without loss of income for Alberta's 9 observed statutory holidays, and this pay is called average daily wage. Some employees may also be eligible for additional general holiday pay for when they work on a general holiday. Employees and employers must give each other notice of their intention to end employment for most positions. Depending on the length of service with the employer, an employee may be required to provide 1 to 2 weeks of notice. For employers, they may be required to provide 0 to 8 weeks of notice. The length of notice increases with the years of service. Employers may terminate employment by providing notice, pay in lieu of notice, or a combination of both. In instances where employment ends due to employment of 90 days or less, seasonality, the end of a term or contract, or for just cause, termination notice is not required. There are many other scenarios where termination notice or pay is not required. Please visit the link on the slide to find out more. Temporary layoffs apply when the employer decides not to use the services of an employee for a period of time, but intends to maintain an employment relationship with the employee. Under the code, employers may temporarily lay off an employee for up to 90 days within a 120-day period. Prior to the expiry of the temporary layoff, employees should be recalled in writing in accordance with the code. However, if the employee is not recalled, the employment is deemed terminated and termination pay may apply. If an employee fails to return to work after being served a recall notice, termination pay is not required. Job protective leaves entitle employees to time off without pay to attend to specific types of personal or family matters. The basic eligibility for these leaves is that the employee must have been employed for 90 days with the employer. All job protective leaves are unpaid, though the employer always has the option to pay an employee during the leave. Employees may not be terminated for requesting to take a leave or for being on a leave. At the end of the leave period, employees should be reinstated to the same or similar position which they held prior to the leave commencing. Common types of leave include long-term illness and injury leave, critical illness leave, compassionate care leave, maternity and parental leave, bereavement leave, and personal and family responsibility leave. Leaves vary in length and specific eligibility requirements. For example, employees may be required to provide medical certificates to their employers or give advance written notice. Permits can be given for children to work in specific circumstances. For children 12 years of age or younger, they are only permitted to work in artistic endeavors. There are opportunities for employers to apply for additional variances or exemptions not laid out in the legislation. Any employer, employer group, or association may apply for a variance or exemption to the Director of Employment Standards or the Minister. An approved application would become the new minimum standard applicable to those parties as named in the variance or exemption. Where the minister may vary any part of the legislation for applicants, the director can only amend specific categories. These are the general rules that have been shared. However, there are many other exemptions and exceptions that exist to the minimum standards. The type of industry and job position usually dictates if there are different rules. It's important to examine each case to determine which rules apply and to whom. Please visit our website for more information on exemptions and exceptions. Now let's look at how administration and enforcement is approached within employment standards. Complaint resolution is one of the largest units within our branch. Complaint resolution includes the Complaint Resolution Unit and the Special Investigations and Inspections Unit. Each unit performs largely the same work, with the Special Investigations and Inspections Unit focusing on vulnerable workers and chronic noncompliance. I'll give you a moment to review the bodies of work for these teams. Both employers and employees share the responsibility to comply with employment standards legislation. Throughout the rest of the presentation, you'll hear me refer to officers a lot. This is in reference to our employment standards officers, who are working to assess employee complaints and third-party inquiries to determine the most appropriate course of action. The Employment Standards Director plays an important role in administering the employment standards legislation. The Director delegates authority to officers to carry out their powers under the Code, as well as approving or revoking permits or variances, among other abilities. The overall objective is to ensure minimum standards are met and, if applicable, that employees receive their entitlements as outlined in the legislation. Complaints are generated in our office in these three main ways. 1. Employees who believe they have not been paid properly or have other employment standards related concerns may make a complaint with our office. Complaints may come through our website portal or be in paper form. When we refer to a written complaint, this means that it is a documented record of the concern and not just an informal phone call to our branch. 2. Officers who identify additional concerns while conducting investigations can open a payroll inspection, which is a tool used to review compliance for the company rather than just an individual employee. An officer may conduct an inspection, investigation, or inquiry to determine whether the rules are being followed, even if the officer has not received a written complaint. 3. Anonymous tips are submitted online and provide anonymous information that can lead to discoveries of noncompliance or human trafficking and exploitation of vulnerable workers. In respects to written complaints, employment standards encourages employees to try resolving their concerns directly with their employer first. This encourages the parties to begin or maintain open lines of communication. As disputes may occur due to misunderstandings or improper information, having the parties discuss these issues outside of employment standards allows an opportunity for resolution prior to the concern reaching our office. When a complaint is submitted, employees provide information specific to their concerns. If they are aware of other individuals affected, they may be asked to inform others to submit their own complaint. In certain circumstances, officers may take concerns into consideration for conducting a payroll inspection, and we will discuss this in more detail later. A complaint may be made for earnings outstanding or non-monetary concerns, such as not receiving a statement of earnings, working outside of maximum hours, or not receiving appropriate rest periods. All employers who must follow Alberta Employment Standards rules may be required by an officer to produce records for inspection. This is especially true for employers with a long history of noncompliance and employers who employ vulnerable workers, including youth and temporary foreign workers. In some instances, self-directed audits are required. Employers are required to review their records and submit their findings of their audit to an officer. If there are unpaid earnings found, the employer is expected to make the appropriate payments or adjustments to resolve the concerns. Inspections And audits allow officers an opportunity to provide comprehensive education and guidance to the employer and ensure compliance throughout the business and not just for one employee. The code sets out the powers officers have to carry out their duties to achieve complaint resolution. Anonymous tips are just that, anonymous. Employment Standards does not know and cannot find out who submitted the tip. All tips are reviewed, but priority is given to tips involving vulnerable workers, those with information regarding potential human trafficking, or those relating to chronically non-compliant employers. Although all tips are reviewed, not all tips are investigated or result in enforcement action. As the tip is anonymous, no follow-up can be made with the person who submitted the initial concern. Let's briefly review employee or contractor considerations. Here are some general themes we look at within employment standards to determine whether a worker is an employee or a contractor. Direction and control. So we might ask who decides when and how the work is done. Ownership of facilities, supplies, tools, and equipment. We want to know who owns what and who is responsible for it. Chance of profit or risk of loss. So who stands to make a profit or suffer a loss as a result of the working relationship? As well as integration. Do the people performing a service consider themselves to be in business for themselves or for the business they're working for? This review process is also known as the four-fold test. As employment standards cannot accept complaints from individuals who are not employees, we may have to review the working relationship to determine if the worker is protected by employment standards legislation. Here are some comparisons with employee relationships and contractor relationships that also help determine the status of a worker. I'll give you a few moments to read this slide. As you can see, there is not a single piece of information that is relied on to decide whether someone is an employee or a contractor. All factors are considered and examined closely. When a worker is not determined to be an employee under employment standards, we direct them to speak to a lawyer to review their concerns. As mentioned previously, employment standards cannot proceed with a complaint from a worker who is not an employee. More information on employee versus contractors can be found in our Employment Standards Toolkit. For those workers who are considered employees for the purposes of the code, where employment disputes arise and the parties are unable to resolve the matter on their own, the code provides a complaint resolution mechanism that includes mediation, investigation, enforcement, and appeal provisions. Here are the different ways that a complaint may be resolved, and I'll give you a few moments to read this slide. As you can see, when a complaint reaches our office, there are many options for resolution and conclusion. We'll go a little deeper into some of these resolution options in the next few slides. Here is a typical timeline of a regular complaint. As mentioned previously, complaints can be made with employment standards via online or written complaint forms. Upon receipt of the complaint, officers will review and then contact both parties to discuss or notify them of the complaint. Voluntary resolution will be one of the first tools an officer will use. It is an agreement between the employer and employee that resolves some or all aspects of the complaint. Officers may also act as a mediator between parties to assist them in reaching a fair settlement or compromise. The parties agree to resolve the concern without requiring further investigation of the complaint, and mediation can happen at any time. When a voluntary agreement can't be reached between the employer and employee, Enforcement actions commence through a formal investigation of a complaint if noncompliance is identified. The employer may be ordered to pay earnings found outstanding to an employee, take action to ensure the workplace is in compliance, and/or be required to pay an administrative penalty. Parties also have the option to appeal an enforcement action or determination of an officer within 21 days of receiving notice. Both parties have the option to appeal, and the employer has the option to pay the determination. Employees may also appeal a denial of complaint by an officer, called a decision of officer, if no earnings or entitlements were found after investigation. If an employer doesn't pay or appeal an order of officer within 21 days after receiving notice, the order can then be filed with the court and is enforceable as a court judgment and moved to the collections team. This is the last stage of the life of a complaint. Collections actions are taken on behalf of the complainant. The legislation outlines several tools to attempt collection of unpaid earnings, including registering the amount as a debt at the courts, applying liens at the personal property registry, as well as making a director or directors of a company personally liable for the wages of an employee who worked and had earnings at the time the directors were in charge of the company. This is the main work of the Complaint Resolution Unit. The Special Investigations and Inspections Unit operates in a similar manner. However, they also action concerns coming in from anonymous tips, vulnerable workers, temporary foreign workers, and investigate human trafficking complaints. In the next few slides, we will be going further into detail on this process. I'll now provide a general overview of the main process of resolving a complaint. An officer receives a complaint and will request records from all relevant parties, as well as review the information provided by the complainant when the initial concerns was made. The information is reviewed and analyzed to help the officer make an informed decision on the issues. Each party is provided notification of any preliminary findings and asked to speak to them. Either party to the investigation may request to see the records that were provided to an officer and review which records the officer used to make their determination. Opportunities are provided throughout the investigation to allow for the parties to resolve the matter. After a thorough review of records, the officer makes a final determination. If either party disputes the findings, a formal order or decision is provided. Let's review a few processes in depth. One of the first and most important actions an officer will take upon receipt of a complaint is to provide education and guidance to both parties. The employee and the employer may be misinformed regarding what entitlements are or what responsibilities each party has to the other. Once education is given, steps to resolve a complaint will begin as mentioned in the previous slide. As mentioned previously, our first attempts to resolve a complaint will be to seek voluntary agreement. Three approaches include the employer acknowledges the concern and pays outstanding entitlements to the employee, or discussions between both parties resulting in a mutually satisfactory agreement, or officer-guided mediation between both parties results in a resolution to the dispute. In conjunction with voluntary resolution, officers may use mediation to resolve a complaint. This is a general overview of how officers may attempt to facilitate mediation between parties. First, the officer will review the relevant legislation rights and obligation of both parties and will also provide education and guidance for properly applying the rules. Second, facts about the complaint are clarified, such as determining what specific issues are in dispute and for what time periods. The officer may also establish that although an employee has made a complaint for earnings, the employee does not qualify for them. Third, options for resolution are discussed, which explore fair and reasonable resolutions. This can include a voluntary payment being accepted. Lastly, the settlement is confirmed by written agreement. The final document confirms that the complaint is considered resolved and closed. As mentioned in the last few slides, officers will first seek to resolve a complaint through voluntary agreement or mediation. If, however, an investigation reveals that an employer has failed to meet the requirements of the legislation and mediation is unsuccessful, the officer, or in some cases, the director of employment standards, will undertake a non-voluntary approach. This may include one or more of the bulleted points on this slide. Employment Standards assesses all employee complaints and third-party inquiries to determine the most appropriate course of action. The overall objective is to ensure employees receive their entitlements under the legislation. I spoke earlier about orders and decisions. An order comes by way of an order of officer. This is a formal demand for payment of earnings found outstanding. Orders can be appealed. Appeals are assigned to Employment Standards appeals officers, and we'll discuss their roles later on in this presentation. To appeal, the employer must pay the full amount of the issued order and include the appeal fee of 10% of the order amount or $100, whichever is greater. These amounts are submitted to the Register of Appeals for Employment Standards and held in trust until the matter is resolved. The complainant does not need to pay to appeal an order. If an order is not paid or appealed, it will be turned into a judgment registered at the courts. Collection actions are subsequently initiated. With respect to a decision of officer, it is a formal denial of a complaint. After investigation, an Employment Standards officer will indicate in a decision that no earnings were found to be outstanding, or it was determined that the claimant was not eligible for earnings. The appeal process is available for the complainant to dispute the officer's findings. Should a decision be left unactioned, or if an appeal is received, reviewed, and the original decision is upheld, there is no further recourse with employment standards. Once an order or decision is served, the parties have 21 days to appeal. Parties to the complaint can appeal an order of officer should they believe that either the determination is wrong, that the officer erred in their analysis, or that all available information was not considered. Written reasons for the appeal should accompany the appeal when it is submitted. Appeals officers will again attempt to mediate or seek voluntary resolution. If this is not possible, a hearing will be scheduled. The employer's attendance is required at a hearing, and in the event the employer does not attend, a determination can be made in their absence. Depending on the circumstances, the complainant's presence may not be mandatory. Order appeals are heard by an appeal body at the Labor Relations Board, and the Director of Employment Standards is represented by an appeals officer. Decision appeals are reviewed and decided on by an Employment Standards appeals officer. An administrative penalty can be used to deter an employer from contravening or failing to comply with the standards and requirements under the code or regulation, or failing to comply with an authorizing instrument or enforcement action from employment standards. Despite what the name suggests, administrative penalties are not punitive. They are a progressive financial consequence used to encourage employers into long-term voluntary compliance when other enforcement tools have failed, or are unlikely to be effective in getting compliance. Prior to facing administrative penalties, the employer will have ample opportunity to voluntarily come into compliance. There are different penalty amounts depending on the contravention, but generally, a first penalty will range from $500 to $1,500. Penalty amounts may be adjusted on a case-by-case basis. Administrative penalties may also be appealed within 21 days of being served the penalty. If an employer wishes to pay the penalty, they have 30 days from the date of service to do so. A notice of administrative penalty may be issued within 2 years of the alleged contravention or failure to comply. Penalty amounts will increase with repeat contraventions if contraventions occur within 2 years of each other. As mentioned in the last slide, the amount of time an employer can provide payment on an administrative penalty is 30 days. Further, administrative penalty amounts can be increased or decreased on a case-by-case basis by the Employment Standards Director. Now that you know the responsibilities and abilities of our complaint resolution units, I'd like to share more information about other units. Here are the duties of our Temporary Foreign Worker Advisory Office, which works in association with the complaint resolution teams. Advisors work closely with foreign workers who are looking for information on their rights and obligations. With knowledge of the federal worker programs, this unit is well equipped to support these workers in their unique working relationships. Aside from the Government of Alberta's website, the Employment Standards Contact Center is typically the first place Albertans go to find information regarding employment standards. The Contact Center answers common or complex questions from Albertans looking for guidance and information for their specific cases. When advisors are unable to assist callers, they may refer callers to other government departments, agencies, associations, courts, or law enforcement bodies. The Contact Center also assists to track trends and common concerns to help employment standards understand which topics might need more public education and resources. There are many workplace-related questions and concerns that employment standards does not cover. Each day, our teams receive numerous requests which are referred out to different agencies and governing bodies. Some of the most common referrals we give are for records of employment or ROEs and employment insurance questions, which are directed to Service Canada. At times, there are tax-related questions, which are directed to the Canada Revenue Agency. Questions regarding workplace injuries, safety concerns, discrimination at the workplace, or unethical conduct by the employer are referred to the Workers' Compensation Board, Occupational Health and Safety, or the Human Rights Commission. Albertans may also be advised to consider reviewing their concern with a lawyer. Overall, the teams at Employment Standards provide general information regarding the minimum standards in the legislation. The information is not intended to be legal advice. Additionally, although parts of the legislation covers employees under a collective agreement, employment standards cannot investigate complaints from employees covered under a collective bargaining agreement. These employees will be referred to their respective union or the Labor Relations Board if they feel they are not being represented properly by their union. Let's wrap up today's session. First, we did a brief employment standards mini overview, and then we looked at employment standards administration and enforcement, including an overview of the complaint resolution process within employment standards, roles of the employment standard officers and the employment standards director, and the mediation process. We have many resources out there for you to find out more information. Please remember to visit our website. The full link is here for your reference. There you'll discover Employment Standards Easy Checks, which are online questionnaires on various employment standards topics, as well as find recorded webinars and learn about upcoming dates of future live webinars. Please note the King's printer is responsible for providing copies of the Employment Standards Code and regulation. Remember that if you need to make a complaint, you can go to our website with the web address on your screen. If you want to contact us or ask a question, please use our contact page listed on the slide. Additionally, you can utilize our contact center toll-free at 1-877-427-3731. And if you want to share an anonymous tip with employment standards, the link is also provided on the slide. So this concludes our presentation on employment standards, administration, and enforcement. Thank you for watching, and we hope that you have a pleasant day.